Zoom recording. Okay, so we're back recording again now. All right, I'm going to share screen and we will get over to transaction desk. There we go. All right, so we are sharing this screen. I think when we left off last time, I think we left off at, line 285, the verbal discussions will not extend. That's where we're going to pick it up from this time anyway. Even if it's not where we were, that's where we're starting. So, line 285, verbal discussions will not extend time periods. Only a written agreement signed by both parties will extend response times or cancellation rights. So if you need extra time to respond to inspections or anything along those lines, make sure that you get it in writing. You can't just call the other guy and say, hey, we need to extend our times. I'm just going to back up real quick here because there's a couple of quick items in here that I just want to make sure that we all understand. Go away. So after you get your bins of response goes back to the seller, you give them the opportunity to respond to what you're asking for to be done. It has to be responded to within 5 days after you deliver them the binzer. So they have to respond in writing within the time period. If they don't respond within the 5 days, it's deemed that they are not making any repairs. So no response means that they are making no repairs. So at that point, if your buyer at that point has to make a decision, and they have 5 days to make the decision. So if the seller is unwilling or unable to correct any of the items, the buyer may cancel the contract within 5 days after delivery of the seller's response or after expiration of time of seller's response, whichever occurs first, and the earnest money shall be released to the buyer. If the buyer does not cancel the contract within 5 days, the buyer shall close escrow without correction of those items that seller has not agreed in writing to correct. So by not responding, it means they haven't agreed in writing, which means they're not making the repairs, which means your buyer has to then decide, do they want to continue or not? And they have 5 days to decide that. Verbal discussions will not extend those time periods. That needs to be done in writing. Now, let's say that the 5 days go by and the seller doesn't respond. And your buyer's like, well, geez, I really, really want to have a couple of these things taken care of or I can't go on. Within that 5 day period, you can contact the seller's agent and hopefully get them on board with, making the repairs. And if they say, yeah, you know what, we will make repairs or we will offer a credit in lieu of repairs. What you can do is if they get an addendum that they're offering a credit, that's fine. If the addendum signed, you're good to go. If they are going to decide they are going to make repairs, then you need to create an addendum that will extend the response time of the seller to X date that will allow that addendum will allow the binzer to then become an active part of the contract that they will make those repairs. So again, make sure that it's in writing. Buyer's failure to give notice of disapproval of items or cancellation of this contract within specified hereby time period shall conclusively be deemed buyer's election to proceed with the transaction without correction of the items. Same thing that it says here in line 283 and 284. They just put it in big, bold, capital letters down there so that you understand. If you don't cancel in that 5 days, you're agreeing to go on without repairs. All right, home warranty plan. The buyer and seller are advised to investigate the various home warranty plans available for purchase. The parties acknowledge that different home warranty plans have different coverage options, exclusions, limitations, service fees, and most plans exclude pre-existing conditions. The home warranty will be ordered by the buyer or the seller with the following optional coverage, which would be like pool coverage, or if there is if they are opting for a plus package of some kind within the home warranty, you can state that in there. To be issued by whatever the company is that your buyer or seller, whoever is making that choice, whatever company they decide, at a cost not to exceed X amount of dollars in there. A lot of times we don't know what the dollar amount is going to be. So what you want to do is just get a rough idea as to what you think it's going to cost. And you can get estimates by just looking at online as to what they're going to cost per company. And then you can throw that dollar amount in there to be paid for by the buyer or the seller, or split evenly between buyer and seller. Or the buyer declines the purchase of a home warranty. If the buyer says they're going to pay for it on their own, but they want to do it later, then you're going to say the buyer declines the purchase of a home warranty plan. Because if they're not purchasing it now, most home warranty companies will allow you a 30-day period after close of escrow to purchase your home warranty if they want to do it. Most, but just make sure that you check them out first. And always, always, always make sure that you are giving your buyer more than one option for a home warranty company. I usually give 2 or 3. 3 is the safest bet, but at least give them 2 and give them options and tell them to choose the one that they are most comfortable with, the one that is going to fit their needs. Walkthroughs. Buyer grants seller and buyer's inspector reasonable access to conduct walkthroughs of the premises for the purpose of satisfying buyer that the corrections or repairs agreed to by the seller have been completed and that the premises are substantially the same condition as the date of the contract acceptance. If the buyer does not conduct such walkthroughs, buyer releases seller and broker from liability for any defects that could have been discovered. So walkthroughs means that, when they're getting repairs or your final walkthrough, those kind of things, they're going to allow you access, but if your buyer decides that they don't want to do those inspections, you're not going to be responsible for them. But I like that term, reasonable access. So they have to provide you reasonable access. If there's a tenant in the property, you have to follow Landlord-Tenant Act, but that doesn't mean the tenant can say, no, you can't come in here. Your landlord has a right, 48-hour notice, they have a right to enter the premises. So that is not a reason to say, no, you can't go in and take a look at the property. Now, they may say, that particular day is not going to work for whatever reason. As long as it's, a legitimate reason as to why they, can't go in that particular day, they can always, deny you once, but they can't continue to deny you access to the property. Seller's responsibility regarding inspections and walkthroughs. The seller shall make the premises available for all inspections and walkthroughs upon reasonable notice by the buyer. Seller shall, at seller's expense, have on all utilities, including any propane, until close of escrow to enable buyer to conduct these inspections and walkthroughs. So that means if they have got a built-in grill, they need to have propane in that built-in grill tank so that it can be tested. Now, one of the questions, and this has come up before, if you have somebody that's got let's say somebody has a heated pool and they have a big propane tank on the property, and that propane tank is a leased propane tank, or they've got a company that comes in and fills it up, and that's what heats the pool. Now they've got to keep propane on until close of escrow, but at close of escrow, here's a question to you. Does the propane need to stay, or is the propane personal property and then the seller gets to take the propane with them?
Does it depend on what kind of tank?
Not unless it's in the ground. If it's in the ground, right, the propane still is deemed personal property. There was a court case about it. So the propane would be deemed personal property. So if the seller could get the propane out and put it into another tank, transfer it into another tank, they could take the propane with them. So that's kind of a funny little thing in there. It's like, really, they can leave you without propane? Yes, they can. That is considered personal property. Okay, IRS and FERCTA reporting. The Foreign Investment in Real Property Tax Act provides that if a seller is a foreign person, a buyer of residential real property must withhold federal income taxes up to 15% of the purchase price unless an exception applies. That's a big line right there. A buyer of residential real property must withhold federal income taxes of 15%. So it's the buyer's responsibility to have that 15% withheld. And that's why it's very important for the buyer to be able to have the opportunity to have the title company that they want, because then they know that the title company is going to do what needs to be done, especially when it comes to FERCTA. If FERCTA is applicable and buyer fails to withhold, the buyer may be held liable for the tax. Buyer agrees to perform any acts reasonable or necessary to comply with FERCTA and IRS reporting requirements, and buyer is responsible for obtaining independent legal and tax advice. So that's a big piece there that your buyers need to understand, is if it is owned by a foreign investor, or if it's a second home for somebody, a Canadian resident or somebody that's foreign, they need to disclose that right away. So they need to let your buyer know, so that your buyer knows that this needs to happen, and so that the title company knows that they are going to have to potentially hold money back. There are exceptions, and there's some great FERCTA classes out there that I would highly suggest you make yourself familiar with, so that you can understand what the rules are for FERCTA. There's exceptions as to when it doesn't have to be withheld. So it's good to know those, so you can kind of give your buyer a clue as to the things that they need to do some more research on and get some more information on. But really, they need to talk to a legal or a tax person to tell them, what the implications are on it. All right. 7, remedies. Cure period. A party shall have an opportunity to cure a potential breach of this contract. If a party fails to comply with any provision of the contract, the other party shall deliver a notice to the non-complying party specifying the non-compliance. If the non-compliance is not cured within 3 days after delivery of such notice, cure period, the failure to comply shall become a breach of contract. If escrow company or recorder's office is closed on the last day of the cure period and close of escrow must occur to cure the potential breach, the close of escrow shall occur on the next day that both are open for business. So, big piece in there is this does not say that it's business days. It says that you have 3 days to cure the cure notice, to get back in compliance. So if on a Thursday you get a cure notice, day 1 would be Friday, day 2 would be Saturday, day 3 would be Sunday. So if you don't have it cured by Sunday, Monday rolls around, they can cancel. They can't cancel on a Sunday. But if it happens to be for, a lender not getting in your LSU or, something along those lines, or not getting documents to title in time, that kind of thing, then, it's got to fall. If it's a close of escrow that is the cure, that you did not close escrow and they cure you on it, and that happens on a Friday, well, that's good news because you've got until Monday to get it closed, and hopefully you get it closed on Monday, or get something signed, an addendum or something that extends your close of escrow date. Breach. In the event of a breach of contract, the non-breaching party may cancel the contract and or proceed against the breaching party in any claim or remedy that the non-breaching party may have in law or equity, subject to the alternative dispute resolution obligations set forth herein. In the case of the seller, because it would be difficult to fix actual damages in the event of the buyer's breach, the earnest money may be deemed as a reasonable estimate of damages, and seller may, at seller's option, accept the earnest money as seller's sole right to damages, and in the event of the buyer's breach arising from buyer's failure to deliver the notice required by Section 2B, or buyer's inability to obtain loan approval due to the waiver of the appraisal contingency pursuant to Section 2L, seller shall exercise this option and accepts the earnest money as seller's sole right to damages. An unfulfilled contingency is not a breach of contract. The parties expressly agree that the failure of any party to comply with the terms and conditions of Section 1D to allow close of escrow to occur on the close of escrow date, if not cured after your cure notice is delivered pursuant to Section 7A, will constitute a material breach of the contract, rendering the contract subject to cancellation. So there's a lot of stuff in that paragraph right there. There's some of the key points that you want to try to remember in here is that the sellers really, their really only recourse is earnest money. And that's why it's really nice to have a decent amount of earnest money put in. If you're the seller, if you're the seller's agent on that, you want to make sure that there is some sufficient money in there. Like we like to term it, skin in the game for the buyer, so that they don't just want to walk off on it, and so that it makes it worthwhile for your seller for taking their property off the market if the buyer happens to end up breaching contract. Now, if the seller breaches contract, if the seller ends up with a breach on it, at that point, then there are lots of other fun things that need to happen or that can happen on the buyer's part. Least of all would be that if the seller breaches, the buyer's broker may go after the seller for commission, because the buyer has brought, or the buyer's agent has brought a ready, willing, and able buyer, and in that case they have earned their commission, so they could actually go back and sue the seller for specific performance and potentially make them pay a commission to the buyer's agent. Usually this kind of thing happens if a buyer thinks that they're going to be able to put the thing back on the market and make more money out of it. I actually had this happen a long time ago, one of my very first transactions, where we got into the escrow period, and we were about 3 days from close of escrow, and my clients were moving from Rhode Island. They had everything loaded up in their truck. They were halfway across the country, And the seller said, yeah, I'm not going to sign documents. I'm going to put it back on the market because I know I can make another 40 grand off it if I go ahead and put it back on the market. Well, that may have been the case, but my broker had told them that we will be suing them for specific performance. The buyers will also be suing them because they are crossing country right now. They've got everything in a truck. So all of their expenses that they are going to incur until we can get this rectified, they will be suing for those dollar amounts as well. So his $40,000 that he's going to be able to get more for his property are probably going to be eaten up and a lot more when it comes to legal fees and everything else when it's all said and done. So with that being written by our broker and that letter sent over to the selling agent and they gave it to the seller looked at it and went, oh, maybe we'll just go ahead and sign. So they went ahead and signed the documents and we closed on time, thank goodness. But sometimes buyers just are, sometimes sellers just, they lose their mind a little bit. They start seeing green and it can turn into some ugly situations. There's tons of fun stories out there. And as you're in this for any period of time, you're going to discover these fun stories that you can end up sharing down the line. Alternative dispute resolution. Buyer and seller agree to mediate any dispute or claim arising out of or relating to this contract in accordance with the realtor's dispute resolution system or as otherwise agreed. All mediation costs shall be paid equally by the parties. In the event that mediation does not resolve all disputes or claims, the unresolved disputes or claims shall be submitted for binding arbitration. In such event, the parties shall agree upon an arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to the American Arbitration Association in accordance with the AAA arbitration rules for real estate industry. The decision of the arbitrator shall be final and not appealable. Judgment on the award rendered by the arbitrator may be entered into any court of competent jurisdiction, notwithstanding the foregoing. Either party may opt out of binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event, either party shall have the right to resort to court action. So if it goes to mediation, mediation is the first step, and if you can't get it resolved in mediation, then it would go to an arbitrator unless one of the parties said, nope, I'm not dealing with an arbitrator, I want this to go to court. So at that point, they would forego going to an arbitrator. Basically, really what it all boils down to is by that time, you've got legal fees that are starting to pile up, and it just becomes a point where any amount of money that you think you were going to be able to walk away with is going to be gone. It's going to start costing a whole lot of money. Real estate attorneys are expensive. Exclusions from ADR. The following matters are excluded from the requirement from the ADR hereunder. 1, any action brought in the small claims division of an Arizona Justice Court up to $3,500, so long as the matter is not thereafter transferred or removed from the small claims division. 2, judicial or non-judicial foreclosure and other action or proceedings to enforce a deed of trust, mortgage, agreement of sale. 3, an unlawful entry for detainer action. 4, the filing or enforcement of a mechanic's lien. Or 5, any matter that is within the jurisdiction of a probate court. Further, the filing of a judicial action to enable the recording of a notice of pending action, a lis pendens, or order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver of the obligation to submit the claim to ADR, nor shall such action constitute a breach of the duty to mediate or arbitrate. So those pieces there, those items in there are things that cannot be gone through the alternative dispute resolution. They would not go through mediation and arbitration. Those things would just, some of them are court actions. Almost all of them are court actions. So if it's a court action, that's not going to be mediated or arbitrated. Attorney fees and costs. The prevailing party in any dispute or claim between buyer and seller arising out of or relating to this contract shall be awarded their reasonable attorney fees and costs. Costs shall include, without limitation, attorney's fees, expert witness fees, fees paid to investigators, and arbitration fees. Again, you're seeing a lot of fees. Those things are going to just eat up any amount of money that somebody thinks that they're saving by going to this arbitration or mediation. Your best bet, and you're going to find this if you were ever so unfortunate enough to get involved in an arbitration hearing, you are going to be very much advised to try to settle and not let this go further, because if it goes past the mediator, it becomes an all or nothing at that point. So what most people will end up doing, they'll end up settling for a portion, they'll end up maybe splitting whatever it is that they were talking about, just so that they can get through it and not have an all or nothing situation. Sometimes, though, it's worth it to go all the way to all or nothing if you're 100% certain you're in the right. All right. So page 8 out of 10 is the additional terms and conditions. So if you have an escalation clause or something along those lines, you would put those in this additional terms and conditions. If you're using, other terms that are in the, if they are on the additional clause addendum, you don't have to put them in here as well. The additional clause addendum would take the place of having to write them in here. I really like to keep this as clean as possible. Some people like to put in here, this page left intentionally blank. I don't feel it's necessary, but if you feel like that's what you want to do, please feel free, it's fine. Some people like to just strike a line through the whole page so that other people can't add things in afterwards. Again, I've never had an issue where that's been a problem, knock on wood. So I'm not a big proponent of that, but if you do, that's perfectly fine. That's up to you. All right, on to page 9. Risk of loss. If there is any loss or damage to the premises between the date of the contract acceptance and close of escrow or possession, whichever is earlier, by reason of fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be on the seller, provided, however, that if the cost for repairing such loss or damage would exceed 10% of the purchase price, either seller or buyer may elect to cancel the contract. There was a situation just last week where this came into play. One of our agents had a buyer, or actually they had the seller. No, we had the buyer. We had the buyer, and the property was supposed to close on Thursday or Friday of that week, and it didn't close because the lender didn't get things done in time. So they extended close of escrow for a week for the lender to be able to get things done. Well, Saturday, somebody ran a car into the house and completely destroyed the carport and damaged a big chunk of the side of the house. So at that point, you have to do an assessment. If the damage would have been more than 10% of the cost of the purchase price, so let's say this was a $300,000 house, if the damage would have been $30,000 or more, either the seller or the buyer may elect to cancel the contract. But the big thing about this is who's responsible for that now? Seller's still responsible to make repairs and to make that whole. So unfortunately for them, they extended the close of escrow by a week because the lender couldn't perform. So they are very much not happy that they have got to pay to have the house restored back to its condition that it was at the time of contract, when in fact they should have actually already been checked out at that point and had their check and had their money. So just some fun little things that happen. Permission. Buyer and seller grant brokers permission to advise the public of this contract. The reason that is in there is so that they can put it in, so that we can do advertisements to say that, just sold or just closed or things along those nature. It also grants permission to put the results in tax records, things like that. Arizona law. That this contract shall be governed by Arizona law on jurisdiction is exclusively conferred on the state of Arizona. Time is of the essence. The parties acknowledge that time is of the essence in the performance of the obligation described herein. That means you can't get your, if you're an agent, you can't get your client's signature on something and hold on to it for 48 hours just because you don't want to send it in yet. So time is of the essence when you have to perform as quickly as you possibly can on things. Compensation. Buyer and seller acknowledge that broker shall be compensated for services rendered as previously agreed by separate written agreement. That separate written agreement is what? That's the ER form, the listing form. It is also the MLS plano. The MLS form is where they agree. That's where you will see what the commission is for the compensation is for the buyer's agent in there. that shall be delivered by broker to escrow company for payment at close of escrow if not previously paid. If seller is obligated to pay brokers, this contract shall constitute an irrevocable assignment of seller's proceeds at close of escrow. If buyer is obligated to pay brokers, payment shall be collected from buyer as a condition of close of escrow. Commissions payable for the sale, leasing, or management of the property are not set by any board or association of realtors or multiple listing service or in any manner other than between broker and client. In other words, there is no set fee, there is no set dollar amount that has to be paid. It's not decided by anybody but the buyer or by the seller and the client who is selling the property. Copies and counterparts. A fully executed facsimile, as if we use those anymore, or electronic copy of the contract shall be treated as an original contract. This contract and any other documents required by the contract may be executed by fax or other electronic means and in any number of counterparts, which shall become effective upon delivery as provided for herein, except that the disclosure of information on the lead-based paint and lead-based paint hazards may not be signed in counterpart. So there's a big piece to remember right there. The lead-based paint disclosure cannot be digitally signed. That's what that means there. That can't be signed in counterpart. So that means your lead-based paint disclosure has to be physically signed by all parties. All counterparts shall be deemed to constitute one instrument, and each counterpart shall be deemed an original. Days. In reference to days of this contract shall be construed as calendar days, and a day shall begin at 12 a.m. and end at 11:59. So 12 a.m. is the beginning of a day. So if you have a cure period that started today, if you issue the cure period today, it would go into effect at what time? 12 a.m. So it goes in as 12 a.m. on Thursday. That would be beginning of day one.
Hey, Todd, I have a question on this. Okay, so when it comes to loan docs being at title and or close of escrow for curing, since the title company closes at 5, can you cure at 5:01 or do you have to cure the following day?
You can cure at 5:01, but it will not actually take effect. You can send a cure notice at that point, but it does not take effect because of the way the contract is written. The date ends at 11:59. So even though there's no possible way they can get docs to title at that point, or docs to title at that point, you can't actually, you can file the cure, but it does not become executable until the next day.
So I've actually had some, I can't remember, it was a long time ago, but it was either the agent or title that said that even though I cured at 5:01, because that cure wasn't a possible cure time, that I had to re-cure the following day.
That's not true.
Okay.
There is, and I can't remember the term on the top of my head, but it's right on the tip of my tongue. I can't remember, but it means that essentially what it means is there's no way that you can cure, that you can satisfy the cure. So if there's no way that they can satisfy the cure, yes, you can send a cure notice at that point, but it does not take effect until, like I said, the next day would be when it would actually take effect. But
so then the calendar days would be the following 3 days after that.
Yeah, so tomorrow would not be day one, Friday would be day one. But you can issue the cure notice at 5:01 today. But Friday would be day one of that cure.
Okay, thanks.
And I'll remember the name of the term that I'm looking for. It's escaping me at the moment, but I'll think of it.
Okay.
All right. Days, calculating time periods. In computing any time period prescribed or allowed by this contract, the day of the act or event from which the time period begins to run is not included, and the last day of the time period is included. Contract acceptance occurs the date that the signed contract and any incorporated counteroffer is delivered to and received by the appropriate broker. Acts that must be performed 3 days prior to close of escrow must be performed 3 full days prior to close of escrow. For example, if the close of escrow date is Friday, the act must be performed by 11:59 on Monday. So if you're supposed to close on Friday, your loan documents have to be at title by 11 p.m., 11:59 p.m. on Monday. Does that make sense to everybody? Okay. Entire agreement. This contract and any addenda and attachments shall constitute the entire agreement between seller and buyer, shall supersede any other written or oral agreements between seller and buyer, and can be modified only in writing, signed by buyer and seller. The failure to initial any page of the contract shall not affect the validity or terms of the contract. So if your seller forgets to initial a couple of pages, that doesn't mean that it's a void contract or voidable contract. It is still very much valid and intact. Subsequent offers. Buyer acknowledges that seller has the right to accept subsequent offers until close of escrow. Seller understands that any subsequent offer accepted by the seller must be a backup offer contingent on the cancellation of this contract. Cancellation. A party who wishes to exercise the right of the cancellation is allowed herein may cancel this contract by delivering notice stating the reason for cancellation to the other party or to the escrow company. Cancellation shall become effective immediately upon delivery of the cancellation notice. Not immediately upon receipt, immediate upon delivery. So if you are canceling, I highly suggest that you notify all parties, not just one or the other. Notify title for sure, and always notify the other party as well. And as soon as you notify them, it's canceled. So once you send that in, if you're the buyer's agent and your buyer says, you know what, I don't want to cancel. Well, we already did. I sent it in. It's canceled. Well, but they haven't responded back yet. It doesn't matter. You've delivered the cancellation. You're canceled. At that point, you would have to try to revive the contract again. And as long as title has not let go of earnest money, and as long as they haven't canceled it out in their system, you can most likely resurrect the contract and get it back and put it in place. Most likely, but you're going to want to have a good long conversation with your title person about it first. Does that make sense? All right. Notice, unless otherwise provided, delivery of all notices and documentation required or permitted hereunder shall be in writing and deemed delivered and received when A, 1, they're hand delivered, 2, sent by fax, 3, sent by electronic mail if email addresses are provided herein. So that's a big piece right there. Sent via electronic mail if email addresses are provided herein. So if you don't fill out the back page of this contract if you don't have if the listing agent's information and email address is not in there, that line becomes void, and it means that any email conversations are not valid. If they're sent by recognized overnight courier service and addressed to buyer as indicated in section 8Q, to seller as indicated in section 9A, and to the escrow company indicated in section 3A. Release of brokers. Seller and buyer hereby expressly release, hold harmless, and indemnify brokers of this transaction from any and all liability and responsibility regarding financing, condition of square footage, lot lines, boundaries, value, rent rolls, environmental problems, sanitation systems, roof, wood infestation, building codes, government regulations, insurance, price, and terms of sale, return on investment, or any other matter relating to the value or condition of the premises. The parties understand that and agree that the brokers do not provide advice on property as an investment and are not qualified to provide financial, legal, or tax advice regarding this real estate transaction. This is a kind of a recurring theme pretty much in everything that we do. We are constantly telling people we're not qualified. We are just absolutely not qualified to do anything except pretty much represent them through the transaction. But we're not qualified to give them advice on anything. Kind of crazy.
Well, as a side note, I am a CPA, but I actually tell my clients I'm not their tax advisor.
Right. Absolutely.
I would have to know way more about everything going on in their life and their finances in order to make that determination. So I even go out of my way to say that to them.
That's a great point, Sherry. Just because you may hold a designation as in another profession does not mean that you are an expert on their situation. So that's why it's very important for them to understand that they need to seek their own advice from their own personal tax person or lawyer or whoever it is that they get their advice from, that they need to seek that advice from them and not rely on us to give that information to them, regardless of what our qualification may be outside of the real estate transaction. All right, buyers and sellers' initials required there. Terms of acceptance. The offer will become binding in contract when acceptance is signed by the seller and a signed copy delivered in person by mail, fax, or electronically and received by broker named in section 8Q. By X date, time, Mountain Standard Time. Personally, I like to always put in there, and unless there is some other reason in there, I usually try to put in the end of business day for me is 6 o'clock. So I pretty much always put in by 6 p.m. And it says Mountain Standard Time, but it's Mountain Standard Time is that. It's Mountain Standard Time. And right now we are not on Mountain Standard Time. So 6 p.m. here would be 5 o'clock Pacific time. And that's again why I like to use 6 p.m. is because our time jumps back and forth a little bit. So that's what I like to put in there. Some people will put in 8, 9 o'clock. Some people put in 12, midnight, whatever it is. It doesn't matter. The buyer may withdraw this offer at any time prior to the receipt of the seller signed acceptance. If no signed acceptance is received by this date and time, this offer shall be deemed withdrawn and buyer's earnest money shall be returned. It's funny, it says buyer's earnest money shall be returned. Who's got the earnest money? They're not depositing that earnest money before they get a contract. So who's got the earnest money? Well, it used to be that we would always collect a check. So the agent would have a check in their possession that they would be turning into the title company to open up escrow. So really what that's saying is if you're holding money, you need to give it back to the buyer at that point. I highly recommend that you do not hold earnest money for buyers at all. If you get a check from a buyer for an earnest money, drop it off here at the office so we can get it under lock and key and you're not responsible for it. If it's after business hours, then yeah, you're probably going to have to hold on to it until the next morning when you need to get it out of your hands as quickly as possible.
Would you want the buyer to wire them?
I always like the buyer to wire money. Nowadays, wiring is so much cleaner and simpler and easier that I have my buyers wire money into escrow. It's a much cleaner and simpler way to do it at this point. And then I'm not responsible for holding on to their money.
A little known fact that bit me one time is that a cashier's check with both parties acknowledging that it's lost cannot be fixed for 90 days after the cashier's check is written.
Wow. So that money is just held up for 90 days.
Yeah, so it was in a different capacity. We had sent a payoff of interest. Unfortunately, it was only about $7,500, but we sent it in the mail and they never got it. You know, we all agreed to sign affidavits and everything. And in the fine print, it says until the cashier's check is past the void date, because it only is good for 90 days. Then after that, then you get to sign all the affidavits and paperwork and stuff like that, but nothing like you could have a video of it being shredded and they'd be like, no, it's still 90 days.
What's the law? Crazy.
Mm-hmm.
So let's just look at this again on this terms of acceptance. Let's say that you turn your offer in today and you give them until 6 o'clock tomorrow to respond back to you. Well, 6 o'clock rolls around tomorrow and they still haven't responded back to you. What does that mean?
You don't have a valid contract.
This offer is now withdrawn. It shall be deemed withdrawn and the buyer's earnest money shall be returned. Even if there's no earnest money that's transpired yet, it's deemed withdrawn at that point. Can you resurrect that?
Yes.
Yes, you can. So if at 7 o'clock tomorrow night, the seller comes back and signs the contract and sends it back to me, what do I need to do?
An addendum.
Yep. Okay, so you still do not, some people would say an addendum. A counteroffer is probably the more likely way that you should do it because you do not have a contract. you still do not have a contract, and an addendum should only be used to modify a contract that's in place. So if the contract's not in place, you really should do a counter offer back at that point, which it becomes really weird because it's like, okay, I've submitted an offer. The seller hasn't submitted a counter offer to me. So how do we do this? Well, really what you need to do is you need to have your seller do a counter offer back. The seller has to redo a counter offer and send it back to you. That would be the correct way to do it. You can do it with an addendum, but the correct way to do it is with a counter offer. Does that make sense that you can't modify a contract? You can't modify a contract with an addendum if it's not a ratified contract. That's
Yes.
okay. Good. All right. So this contract contains 10 pages exclusively. Any addenda and attachments, please ensure that you have received and read all 10 pages of this offer as well as any addenda and attachments. So that's back on page 1. Anything that's checked in that box, that becomes part of the contract as well. So we used to put in as part of the contract the market conditions advisory. It's not a required piece anymore, but it's still not a bad idea to have that. But if you put that in here, then it becomes a part of the contract, and then everybody's got to sign off on it. So it's best to have a market conditions advisory outside of the purchase contract and don't make it part of the contract, since the buyer and seller don't have to both sign it anymore. All right. Real estate purchase contract. Broker on behalf of, that is you. If you're the buyer's agent and you're writing this out, that's your information, your MLS code, your agent license number. If there's a second agent involved, if there's a co-buyer's agent or a team member that you want to put on there, you can put their name on here as well. If you're a new agent and if you want to put my name on there, you're more than welcome to put my name and my information on there as well. The firm name, Berkshire Hathaway. Firm code, MLS code. Write this down if you don't know it. It is PRAZ10. That is our MLS firm code. Why is it PRAZ10?
Prudential.
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 Yep, because we used to be Prudential. So PRAZ10, Prudential, Arizona. So we still have that They never change your MLS code, regardless if you change your name or not. You'll find some of these brokers that have the weirdest MLS codes that have nothing to do with what their name is, like ours, and it's because they've changed their name at some point. So firm address, state, zip code, firm license number. If you don't know the firm license number, you can look it up in the MLS. You can look up our office number, and it will have our license number in there as well. Preferred telephone number, fax number, and no, I don't have that number memorized in my head. I probably could rattle it off, but it might be slightly wrong, so I don't want to try. The license number, yeah. Telephone number, email, agency, and so the agency confirmation that says that the broker named in the section above is the agent of either the buyer, the seller, or buyer and seller. So if the selling agent is also a Berkshire Hathaway agent, then we would check the both box there. So then you have the buyer's information here. You've got the seller's agent information here. Again, this should populate for you if you're using, if you're pulling it in from in Transaction Desk, if you're pulling it in and connecting with the MLS, it will pull all this stuff from the MLS and fill this out for you. But you want to double check and make sure that it's all in there, because again, some of these brokers in here don't have their complete information in the MLS. So it may not come across all the way, and then you might have to go back and dig it up and try to find it, or call the other agent and get it from them if you can. But don't send this over not completed. This needs to be completed. Seller confirmation, again, this is where the seller above the agent represents either the seller or both the seller and the buyer. The undersigned agreed to sell the premises on terms and conditions here stated herein, acknowledge receipt of a copy of, and grant permission to broker named in section 9A to deliver a copy to the buyer. So if the seller signs this, it means yes, they're going forward with it, and they give you the permission to send it back to the buyer. Or the counter offer is attached. They would sign this, and then if they want to do a counter offer, they would check that box and say, we're sending a counter offer back to you. The seller must sign and deliver both this offer and the counter offer. If there's a conflict between the offer and the counter offer, the provisions of the counter offer shall be controlling. So the counter offer takes precedence over what the terms of the offer is if there's a counter offer. Information there. Offer rejected by seller. So if the seller rejects the offer, You would check that box there, month and date that they reject it, and then the seller would initial it right there. The seller doesn't have to sign the rest of the contract, and they shouldn't sign the rest of the contract if they're rejecting it. But you should always ask your sellers to sign or to initial a rejected offer. Broker use only down here, you don't have to worry about any of that. That's for broker review when they're reviewing your log. Because this contract has to be it has to be reviewed within how many days by Arizona state law? The contract has to be reviewed by the managing broker within 10 days of when it is signed. Our company policy is that this needs to be in SkySlope within 24 hours. They want this within 24 hours so that it gives them the time to actually get it reviewed. So 24 hours is your time period to get it into SkySlope. Make sense? Look at that, guys. We sailed through this class today. We're only at 1:45, so we got a 45-minute class today. Is there any other questions that you guys have? Anything that you guys want to bring up?
Once you upload it into SkySlope within 24 hours, what if it still just says in pre?
If if it says that it needs to be reviewed, that's fine. As long as it's in SkySlope, you're good. It can say reviewed, hopefully not for 10 days, but it can say that it's to be reviewed for however much time. That's not going to affect you at all. You're fine as long as you get it uploaded into SkySlope, you're fine. And I know that they're a little behind at corporate right now getting everything reviewed. They've had a couple of people that have left, and so they're a little behind on getting everything reviewed. But Jamie's doing her best to get all the contracts reviewed as quickly as possible. All right, any other questions, guys? All right, thanks for joining in.
Thank you.
Thanks, Todd.
You're welcome, guys. I will talk to you soon.